You're listening to Honestly Aging by VigRHealth, a podcast where we explore what it's like getting older, the peaks, the valleys, and everything in between. In this season of Honestly Aging by VigRHealth, we're covering topics related to solo aging. I'm your host, Cheryl Proska. Let's grow old together. On today's episode, I'm joined by elder law attorney Rob Slutsky. Rob has been practicing elder law for over 30 years. He advises clients on Medicaid and asset protection planning, special needs planning, guardianships, wills, trusts, powers of attorney, estate administration, and general estate planning. Rob has been named the #1 top elder care lawyer around the Mainline and Western Suburbs for several years by Mainline Today magazine and named on the PA Super Lawyers list again in 2022. He's able to plan for you and your loved ones in a timely and cost-efficient manner, and so much more. Rob, welcome. Thank you for being here. How are you?
I'm doing great. Thank you for having me.
Absolutely. Rob, you are joining me today to discuss advanced planning and what older adults and solo agers need to know to set themselves up for success. We are going to cover topics like powers of attorney, Medicare, Medicaid, long-term care planning, and more. So let's get started. Rob, what is a power of attorney?
Well, in its basic form, a power of attorney is a written document where you authorize another person to make identified decisions for you, whether those decisions are medical or financial. That's what it is in its simplest form.
And once you make those designations, when would a power of attorney become effective?
Well, that's a trick question. And one thing that we probably learned like the second day of law school is it depends. So when you have that question, you have to look at the document. Most powers of attorney that are drafted today, unlike previously, are effective immediately, meaning once you sign the document, the person that you name, and I'll define who that is. So if I'm giving power of attorney, I'm the principal, and the person who I name to make decisions for me would be my agent. So in most powers of attorney in 2022, they are effective immediately. So if I execute it in your office today, my agent can take that to the bank or take it to my doctor's office and use that to get access to my funds to help me out or to talk to my doctor about medical decisions. And, typically there's a HIPAA release in there so that they can have access to my protected health information. There are documents out there, and I think many people have a misimpression that they're more that these are more used more often, and they're called a springing power of attorney. A springing power of attorney has a condition before you can actually help me if you're my agent. So this condition often is, well, when somebody says I'm incapacitated, or when my primary care physician, or when 2 doctors from Pennsylvania say I'm incapacitated. And springing powers of attorney, as a practical matter, are used very infrequently by elder law attorneys because our goal is to make sure that our clients have someone who can jump when they need help and be right there and have immediate ability to assist us. So when you have a springing power of attorney, you're putting up a roadblock that's going to make it more difficult for your agent to actually jump in and help you when you need the help. Typically, financial institutions are going to look at a springing provision and they're going to make it extremely difficult, and they're going to delay your agent having access to your funds, which is most of the time not what you want. So I will not use, or I don't use springing provisions. And I think most elder law attorneys who do this every day do not use springing provisions.
It, to me, sounds like a good idea, but then once it goes to be executing, you think you're setting these precautions up, but the way that you put it as it could be a hurdle, that makes complete sense to me.
Well, think of it this way. Why would you want to put that hurdle? Some people, and when I do public presentations and I ask that question to the audience, they kind of hem and haw, and they kind of say, well, I'm not 100% comfortable with someone taking over my stuff. And my question to them is, well, if you had the confidence in this individual to name them, you should have the confidence for them to have access to your information today. If you don't have confidence in their ability to make the right decisions for you, or you're not comfortable with them having the ability to act on your behalf today, what makes you think they're going to become more trustworthy when you have no ability to watch over their shoulder?
And that leads me to my next question, which is, why is a power of attorney one of the most important considerations in estate planning?
Well, because you got to look at the alternatives. So what happens if you don't have a power of attorney? Okay, so in Pennsylvania, and again, I'm a Pennsylvania lawyer, so I speak about Pennsylvania law only. I can't speak to other states. But in Pennsylvania, if you don't have someone for healthcare decisions, there is a backup. It's called the healthcare representative law, and it allows some decision making by identifiable blood relations, which typically start with your spouse, could include your children, and it goes down to people who know you, which is tough, because how they know you or how well they know you is going to be up in the air, but it's not really comprehensive. And if you don't have a power of attorney for financial, there is no backup under Pennsylvania law. This means that if you don't have someone who is named as an agent under power of attorney to make financial decisions for you, your only option is going to be going to court and getting a court-appointed legal guardian. That has multiple issues. The first is it's complicated, it's time-consuming, it's costly, and you're leaving it up to a judge who doesn't know you to make decisions about your welfare. So if I write a power of attorney, I can express my preference and say, I trust Cheryl, I know her judgment is good, and therefore I want her to make my decisions if I can't do it. But if I don't name Cheryl, then I'm leaving it up to a judge who is a stranger, who might be a great person, but may not have the ability to really divine what I wanted. So that judge is going to appoint who they think is right. That person may or may not do the things that I would want done. Another thing, in addition to the cost, inconvenience, and unknowns of a guardianship, is the guardianship law places guardians under certain restrictions. So whereas I can be very broad and very precise as to the powers that I authorize my agent to have in my written document, the judge has to follow what the law says. So for instance, a common provision in a durable power of attorney for finances is that the agent can sell my house. Simple transaction, happens every single day. With a guardianship, the guardian can't do that without getting court approval. So they have to get a listing agreement, they have to get a proposed buyer, then they have to hire a lawyer again to file a petition to show the judge that the house is being sold for a fair price to an unrelated buyer. So this delays the process. It might knock some potential buyers out. And again, there's the added cost because you have to hire a lawyer, and the petition may require a hearing. So you could end up paying a few $1,000s for something that with the power of attorney would have no cost involved other than normal closing costs. So, and there are certain things that a guardian just simply cannot do, even with court approval, that you can authorize them to do in your power of attorney. So a power of attorney is much more flexible than a guardianship. It's much less costly, and it's you maintaining control. You're making the choices as to what powers you want to give, and you're making the choices as to who you want to give those powers. Someone hopefully who you trust and know, as opposed to a complete stranger that will be chosen by another complete stranger.
This makes me think of large families where these conversations and decisions aren't really made known. And then you have the brothers and the sisters getting into these arguments about what should or should not happen to mom or dad. So not having these in place feels like it would lead to some of those really tough situations.
It absolutely does, and that's why it's called planning. I mean, this is why you're doing it. Look, people who are selfish don't plan. If you don't care about other people, you don't plan, because somebody will take over when you can't. But when you're doing this type of planning, you're doing it not for you so much. You're doing it for the people who you care about, for your spouse, your partner, your kids, your nieces and nephews, because you don't have kids. So it really depends on your situation. But people who do planning are doing it because they are trying to minimize stress on other people, as well as have a good plan in place so that they get proper care as they age.
Would you prefer to age independently in your own home or live in a nursing facility? I know what I'd rather do. Friends Life Care membership offers just that. Plan today for a future lived at home with vitality, independence, growth, and resilience while protecting your savings. Learn about your options at a free seminar or webinar. Register at friendslifecare.org/register or call 215-628-8964. Welcome back to Honestly Aging by VigRHealth, where today I'm joined by elder law attorney Rob Slutsky to discuss advanced planning for older adults and solo agers. Rob, how does a will control the disposition of your IRA funds?
Okay, well, it may or may not. One thing that people are often confused about when we do planning is assets that have a beneficiary designation and the interplay between that and your will. So a will is intended to control assets that are called probate assets. These are assets that are in your name alone when you die, meaning they're not jointly held with another person, and they don't have a beneficiary designated on the asset that will pass to that beneficiary when they pass away. People often confuse or misinterpret or misunderstand that if you have, for instance, an IRA, which has the availability of naming a beneficiary after your death, if you have a will, that will does not override the beneficiary designations that you have named. So let's say, for instance, you went to your financial advisor and you went there with 2 of your 3 children. The financial advisor didn't know that you had a 3rd child and named, while you were working with them, just the 2 that were there with you at the time as death beneficiaries on your IRA. But your will reads, I want to leave everything equally between my 3 children. Upon your death, that beneficiary designation will be leaving that money that's in the IRA, which may or may not be a substantial portion of your estate, to those 2 children. In most cases, siblings are going to take care of each other, and it'll be a little bit of administrative inconvenience and maybe some tax problems, but it will get resolved. The problem is there are those situations where if you do that, and it does happen, I have seen it in my 30 years of practice, where one child who happens to be named as a joint owner or as a death beneficiary, and nobody knew that, that child will then cut out their siblings because almost all the assets end up going to that one child because the parent really didn't understand what was occurring when that designation of beneficiary was set up. So it really kind of says when you're doing planning, you have to consider all of the assets. And there are no assumptions in the law. So, if you have assets that are individually held, they don't automatically go to your spouse or to your kids. They're your assets. There is no obligation under Pennsylvania law. Well, I shouldn't say. With regard to your spouse, there is an obligation to give a certain amount, but it's not a huge amount. So if you happen to have, depending upon your marital situation or personal relationship situation, a lot of assets that are in your name without your spouse being the co-owner, that could be a real problem if that spouse relies on you financially and they die. So it's very important that when people do their planning, they consider every asset they have and how these assets are titled and what's going to control what.
So having different people named as beneficiaries of your IRA and then on your will, are these situations that lead to a will being contested and winding up in probate court?
Well, I mean, certainly that's one of the reasons a will can be contested, because I have seen situations where, there's allegations that there was exploitation prior to death, that there was coercion, or that the individual who changed the beneficiary designation to exclude their siblings, they were doing it at a time when the the older adult maybe lacked capacity to understand what they were doing. And certainly those are a very challenging type of case to litigate and very expensive. So ideally, your best bet is, if you love all of your kids, and again, it doesn't have to be kids, it could be nieces, nephews, friends, neighbors, partners, whoever, include them in the process. One of the things that I see is, if I have situation where one child is coming to me separate from all the other kids, I really want to have a deep conversation with mom or dad, because that is a red flag to me. And I want to make sure that what this one child is saying to me is consistent with what mom or dad want, because at the end, this is about them. This is about their money, their life, what they've accumulated, and what their wishes are. And whoever's in front of me is less relevant than the parent and what they envision is going to happen after they go.
Rob, switching gears a little bit, can you cover what is Medicaid and how does it differ from Medicare?
Sure. Medicare is a little simpler, so I'll start with that. So Medicare is health insurance for people who are either over the age of 65 or who are disabled under federal law for at least 2 years, assuming you've paid into the system, because out of our checks every month, every week, or whatever, we pay Medicare taxes. This assumes that you've paid into the system your Medicare taxes for at least a reasonable period of time, and then you're entitled to Medicare. Medicare is not what we call a means-tested program, which means that regardless of how much money, income, or assets you have, as long as you pay taxes into the system, you will get Medicare. So you could be a very, very wealthy person and get Medicare, or you could be a person of very modest means and be entitled to Medicare. Okay. Medicare pays for medical events. So Medicare Part A typically pays for hospital admissions, and Medicare Part A also has an inpatient nursing home benefit. So this would be used if you had, for instance, a stroke or a broken hip and needed to go to a nursing home for rehabilitation. And that program, again, is medically related and medically necessary. But it's a relatively limited nursing home benefit, meaning if you've paid your deductible of whatever that is, a couple thousand at the front of the year, and you need that rehabilitation, Medicare will pay for the first 20 days. Days 21 to day 100, Medicare will pay with a not insubstantial daily copay of about $180 per day. And typically that is paid when people have supplemental insurance. But one thing people have to understand is you're not guaranteed to get that full 100 days of coverage. Medicare will only pay if they feel that the rehabilitation that you're getting is benefiting you in some therapeutic fashion. In other words, they're not just going to pay for you to sit in a nursing home and be cared for if they don't feel like you're going to be rehabbing to independence. So they could stop at day 22 or day 15 or day 99. But Medicare will never, ever, 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 under any circumstances, pay for what is called long-term care or custodial care in a nursing home. This is different from the Medicare rehab benefit. Custodial care is not when a person has an injury that can be rehabbed. This is when the person may be either too physically frail or cognitively impaired to be independent, and they need help with what we call activities of daily living. Feeding, bathing, dressing, toileting. Those are things that are what are called intermediate or custodial care, and Medicare will never pay for them unless you're getting them as part of your rehabilitation benefit to get you back to independence. Medicaid is a different program, but it has similar benefits in some ways. So there's really two separate Medicaid programs. One is the Medicaid that we hear about on TV that the politicians fight about. This is health insurance for people of very modest financial means, that provides doctors, hospital, dental, hearing, vision, whatever. And that's typically provided to younger families that just have limited resources. Medicaid, though, has a separate benefit that is intended specifically to pay for long-term care services. To qualify for that benefit, though, is different than Medicare, because for Medicaid, this is what we call a means-tested program, which means if you have too much money, you will not be eligible to get Medicaid to pay for your nursing home care. Now, there's a lot of tools that we can use, and we'll probably go over them very briefly, to allow Medicaid eligibility and not be totally destitute. But the idea is that Medicaid is not intended to help very wealthy people get their nursing home paid for. It is meant to help people of more modest means, although how Medicaid looks at you, you could have some assets left and still be eligible if you do the right thing. One thing that we also have to understand about how the Medicaid system works is that while the law was originally intended to only be used for nursing home, not home care, not personal care, not assisted living. It was originally intended to be used only for nursing home care. Today, at least in Pennsylvania, we have a special program called the Waiver that allows certain Medicaid dollars to be used for home and community-based services. So Medicaid is different in the sense that when you need long-term care benefit, Medicaid can help you. But there's two qualifiers for that. The first thing, as we discussed, is you need to be financially eligible, meaning you can't have too much money under the way they look at your money. The second thing is that you need to be clinically appropriate, which means that you need to be assessed clinically by either a social worker or a nurse in the county and determine that you need the type of care that a nursing home would typically provide. So that determination is one of the two requirements when seeking Medicaid eligibility, either for nursing care in a nursing home or nursing care in the community.
So you talked about how someone would qualify for Medicaid services. Can you talk about how someone would qualify or go about applying for what I'll call the at-home waiver instead of having to go to a facility?
Okay, so the actual process is very similar, but there are separate parties. The only real difference in the eligibility criteria to get home care versus getting that same type of care in a nursing home is that if you need a high level of care in a nursing home, there is no limitation on your monthly income. In other words, for instance, if Medicaid has negotiated a rate of $9,000 a month with nursing home A, and you're in nursing home A, and your income is $3,500 a month, Medicaid will come in and just pay the $6,500 differential. If you live in the community and you want to get Medicaid waiver services provided in the home, to get that, there is an income cap of $2,523 per month in 2022. It's going to go up the same amount as Social Security will go up in 2023, which is a little under 9%. But that income limitation is basically the primary difference between being eligible for Medicaid in the community versus Medicaid in the nursing home. The actual process is also a little different. When you're in the nursing home, you're applying to the Department of Human Services in both cases, but there's actually different units within the county offices that handle the Medicaid applications. There's different units that handle waiver applications for home care versus nursing home applications. And when you're doing the process for community-based services, there's an extra party that somewhat complicates things a little bit more. And probably the biggest difference between nursing home and getting help in the community is it's a little more challenging to apply for community-based services, because if you're in a nursing home and are now eligible, the state will pay back. They will pay retroactively. So if you're eligible on December 15th of 2022, but it takes them 6 or 8 months to approve the application, they will pay the nursing home back that 6 or 8 months. So you don't have to worry about a period of no coverage and no help, because you'll be getting care for that period. If you're in the community, there is no retroactive coverage. So you have to work the application process a little bit more actively and forward thinking, so that you're spending your assets down during the process, so that you don't have a period where they're not paying and you don't have care. So it takes a little bit more logistical work to make sure that there's no gaps in your care and coverage.
So since I do work at Friends Life Care, I have some exposure to Medicaid and Medicare and what it covers. And a question we get a lot, and I wanted to see if you could help cover it, is how much money can you give away in a year and not affect your payment by Medicaid for these long-term care services?
Well, that's a great question where there's a lot of confusion. So people often answer that question by thinking $16,000 per person per year. And that is not about Medicaid. That comes from the federal estate and gift tax law. And what that says is if you give away less than $16,000 per person per year, it will not reduce your $12.5 million exemption from federal estate tax. For the average individual, that is irrelevant. And certainly someone who'd be applying for Medicaid isn't really worried in general about their $12.5 million federal tax exemption.
I wouldn't think so.
No, generally that's not the case. The answer for purposes of Medicaid is zero. In other words, when you apply for Medicaid, the process gives them the option of seeking 5 years of retroactive bank and financial statements. And they will look at all of your financial records for that 5-year period, and they will ask, have you given away anything of significant value without getting something of equivalent value in return? In other words, I can buy a car from Cheryl that's worth $50,000 and give her $50,000 within 5 years. You've given me something of equivalent value, that's no problem. But if I just write a check to Cheryl for $50,000 and get nothing in return other than her friendship, or she's my daughter, or she's my sister, Medicaid would have a problem with that. And they would penalize your application and they would delay your eligibility based on the size of the gift. So in general, people have to be very careful, because if you are aging and if you are starting to decline and you are throwing large amounts of money at loved ones, and I've seen very weird gifts. I've seen gifts to political candidates, to religious organizations, some less than credible religious organizations, lottery scams. I've seen a lot in my practice, and people have to be aware that if you're going to be making large gifts, you could end up compromising or potentially jeopardizing your own ability to get care when you need it. So people, as they age, have to be a little bit more educated and knowledgeable about what to do with their money, because if they don't, they could very innocently and unintentionally jeopardize their care.
That is a lot to process. And if you didn't know, you would probably just go about giving away thinking it may be to your benefit when really it's to your detriment. So that is really important information to have.
You know, the issue is it's not widely available. People often don't learn about it until they're in a situation where, you know, they ask a friend, what have you gone through with your aging parents or your partner or whoever, or they get a referral to an elder law attorney or another elder care professional, you know, from a hospital caseworker or a doctor's office that might know that, hey, you know, you're having some decline here, you better think about next steps. And it's unfortunate because this just isn't taught in schools, high schools, or other places that are commonly available.
Well, Rob, before we wrap up and I let you go back to all of the other things that you have to do, are there any other pieces of advice or information that you would want to share about advanced planning with the older adults and solo agers listening?
Well, I think you hit it on the head. It's advanced planning. It's best to know this stuff and think about it and make choices rather than have the choices be made for you because you didn't make them for yourself. So I guess the probably the best lesson people can hopefully learn. Well, also, there is no one size fits all. A lot of people come and they've heard someone, you know, some alleged expert, you know, who says, well, this is what everybody should do. There is no, this is what everybody should do. Everybody's case is unique. Everybody's facts are unique, and everybody's preferences are unique because, you know, as an attorney, my job isn't just to give people the law and say, do this. It's to say, first, what's your facts? Second, what are your priorities? And third, say, okay, based on your facts and priorities, here's your options. Then the family can make a choice as to what works best for them. And to recognize, though, that Different priorities means different planning. And maybe asset protection isn't your highest priority. Maybe it is. So it's very much about just thinking ahead and making your choices rather than having someone else make them for you.
Rob, thank you for so graciously sharing your decades of elder law and advanced planning experience. I have learned so much, and I'm confident our listener have too.
Well, thank you. It was a pleasure chatting with you today.
Thank you for listening to Honestly Aging by VigRHealth. You can find links and show notes from this episode on our website at friendslifecare.org/podcast. Thank you to Rob Slutsky for joining us today. You can learn more about Rob and Slutsky Elder Law by visiting www.slutskyeelderlaw.com. Rob is also on LinkedIn, and his law practice can be found on Facebook, YouTube, Yelp, and Alignable. Links to all these resources can be found in the show notes. If you like our show, please rate, review, subscribe, and join us next time. To learn more about aging with vitality, independence, growth, and resilience, subscribe to our blog at friendslifecare.org/blog.